Thank you, Ms. Pacheco. Our second speaker today is Ms. Shannon Guthrie. Ms. Guthrie is currently an attorney at the Benenati Law Firm in Bedford, Texas. Ms. Guthrie received her law degree from Indiana University School of Law. Her practice involves a broad range of estate and tax issues, including estate administration, estate planning, planning for family or closely held businesses, charitable donation planning, gift planning, transfer tax planning, beneficiary designation planning, and creation, planning formation, and tax advice for the public, charities, and private foundations. Ms. Guthrie is board certified in estate planning and probate law by the Texas Board of Legal Specialization. She is an ACTEC Fellow, has been named a Texas Super Lawyer on several occasions, and most recently she was selected by her peers for inclusion in the Best Lawyers in America 2014 in the field of trusts and estates. Today, Ms. Guthrie will be presenting on trust decanting, so please welcome her right now. Thank you.
Okay, I promise I'm not checking email. My watch decided to stop at 10 till 4 this morning. So, and someone, oh, it's on the phone here. That's perfect. So someone wave at me if I kind of run away with this. But just trying to jump into this a little bit and maybe give you background to be helpful. I know that all of you are perfectly capable of reading our new statute on decanting, but I had a somewhat primary role in this new statute in that I served as the chair of the Trust Code Committee for a few years and had the opportunity to serve with there's several people in the room who were there with me working close by, had a lot of information, a lot of experience that they brought to the table. And rather than just, go into a regurgitation sort of thing of what the statute is, I thought that it would be helpful if we really talked a little bit about legislative history, how we got to where we are, and maybe a little bit about where we're going. Although I do not serve any longer as the chair of that committee, I'm still on that committee, and we are actually still working on possible modifications to this statute. So I'll give you a little bit of background just about decanting in general and things you ought to be thinking about. Some of you may be dually licensed considering where you live and how close you are to the borders of different states. So I'll give you a little bit of background and then we'll kind of jump into our statute and things you might look at and go, what in the world is that all about and how'd that get there? So I hopefully can give you a little bit of that information. And certainly one of the things that as part of REPTL Council, which is the Real Estate Probate and Trust Law Council for our state bar, if you ever come across things or you see something that you think might be a good change even to this statute or any other statute, you ought to, number one, get involved, get on the REPTL website and find out who's in charge of that particular area or who is sort of the head person, even the chair, and send your recommendations in because those are very much considered because we still make mistakes and things get missed and things don't, while they might make sense to us while we're sitting in a room working on that, they may not actually make sense in practice or in application. So that's my little speech for REPTL Council. But get involved and pay attention. Your thoughts and your analysis are very welcomed. Okay, so let's go into a little bit of background. I don't want to bore you with a bunch of heavy-duty stuff that's, you could actually read. And one of the things I will tell you is in your papers, part of that, and it's just by good fortune, Melissa Wilm's paper that is being published in the journal is actually attached, so you're getting that as a part of your materials. Melissa had written a paper, a substantive paper, a while back and has been kind enough to allow me to use that previously, but she recently updated it for y'all's journal, so that's a great addition and certainly more broad just outside of the scope of Texas, but there for your reading. And so that's in the back. I'm not really going to go into great detail, but it's just there for you to read and have as a substantive piece of material. Okay, so what is this whole concept of decanting? It's just what you would think it would be. If you're a wine drinker, then you'll get it completely because if you drink wine, a lot of times you will decant, pour your wine into a different a vesicle, I guess you would say a vessel, to hold that wine, and so that it can be there to aerate, those sorts of things. So just the act of pouring it from one vessel into another is a decanting. So it's similar to that. It's the taking of part of a trust and pouring it into some other trust, in essence. So Webster defines decanting as just the drawing off of a liquid without disturbing the sediment or lower liquid layers, or the pouring from one vessel into another. So think of it in terms of taking assets from one trust and simply moving them to a new trust. Now, when this all first started, I will tell you that we had a lot of great, and always have great minds, but a lot of people working on the statute, and it's been about 6 years, I would say, when we started that process. And we got about a year and a half into it and worked on a statute, and we had a committee meeting by phone, a conference call, and I remember, and I won't name names, but it's always interesting when you bring a bunch of people together who have a lot of legislative history, a lot of longevity as far as knowing all the different changes that have come about and understanding how all these things come together. And all of a sudden, you could hear just the over the phone, because the thought of someone changing a trust, moving that, possibly getting around and thwarting the settlor's intent, it was pretty scary to me too. But we were really peeling back the layers of that onion and thinking about all of these things. And as I said, I remember one attorney who said, "This is the greatest thing. We can do so much with this. We can change this. We won't need to go to court anymore. We can do all these modifications. We will totally bypass the court." And you can imagine, just to all of our surprise, that we just started thinking, well, is that really a good idea? I mean, I was taught a trust was irrevocable. If it's irrevocable, it's irrevocable, right? And you ought to always look to the settlor's intent. And oh my goodness, here we are. We're talking about totally doing something different with the trust that we have in existence. So we didn't get very far with that. So the skids were, it was there. We just came to a full halt and said, we're going to step back and wait a little while and kind of see, if we get more comfortable with this. So we pulled back and started over the next session. And, we in Texas go in 2-year sessions, so it takes a long time for us to get our packages and all together, and the deadlines we have, those go in way in advance of when you actually see the stuff coming out in the meetings. So we started working on a new one. And as we started researching more and really getting a little more comfortable with what was going on, it started to come together. And hopefully some of the background I'm going to give you will make you more comfortable with it as well. Because decanting is really not a new concept. It's been around for a while. It's been around. The restatement has addressed it in their donative intent and donative transfer section. It is something that it's akin to a power of appointment, and that's the way the restatement has looked at that. The way that the restatement second looks at that is that it was looked at as the person having a discretionary power to distribute property to or for the benefit of one or more current beneficiaries. That person, in essence, has the power to distribute that to only one of those beneficiaries. So you had a broad class. You pull it in, and you could exclude other beneficiaries. Well, at first, that was hard to get our hands around, but when you start looking at it in that context, well, that makes sense. If I, a beneficiary of that trust, have the power to distribute to any one of the people in this room, why could I not just distribute it to one of you? And why could I not do that in trust? Well, the restatement anticipated that. Now, when the restatement third came around, it picked up on that same concept. It recognizes a beneficiary's right to hold that beneficial interest and then have this power to, in essence, it's a power of appointment, take that, make a distribution to a group of persons or pick one of those persons when they have the discretion to do that. And as long as the trust instrument does not limit that or somehow say they can't do it, then they can even do that in further trust. They could also, why couldn't they also give the person who they're going to exercise this power in favor of, they should be able to give them a power of appointment. They should be able to change that, maybe add beneficiaries, because if they could do that among that class and they have full-blown discretion, then why can't they do that and say, hey, you beneficiary can have whatever power I'm going to give you, and you can exercise that in favor of someone else. And if I give you a general power of appointment, that's almost like an outright distribution. So it's looked at as the same thing. So it's really, really not this new concept, even though the title that we've given it, just by someone coming up with this, that makes sense. All of a sudden we start calling it decanting. And the title's pretty new. You will not find the word decanting in the Internal Revenue Code. And you're not going to find it, at least right now, in any regulations. I doubt you will ever see it. We don't tend to pick up on little coin terms like that. But it is, being considered right now. The service is looking at this. We'll talk a little bit more about some of the ramifications you ought to be considering if you're going to do a decanting, whether it's here or in another state. But you're not going to see that term. But it is what most everyone is calling it these days. Okay, so a little bit about the common law, because we've talked about the restatements, and we often look to that for guidance. We don't, as we all know as lawyers and law students, we don't always agree with those, but it is something we look to for guidance in sort of what we think the law should be and what the law is stated in most jurisdictions. Now, common law also considered the concept of decanting, and one of the big cases, the original cases, was the Phipps case. And in that case, a woman had created a trust and given her husband, who was one of the trustees, and there was a corporate trustee also, but the trust was there for the benefit of her children and the descendants of those children. And that trust gave the individual trustee, her husband, the ability to, in essence, direct distributions, whether it's in some separate writing or in his will, to distribute some or all of the income and principal to any one or more of the beneficiaries in the trustee's sole and absolute discretion. So husband turns around and says, okay, corporate trustee, transfer all the trust property to a new trust. And by the way, the beneficiaries are all of the wife's descendants, so they were included in the original trust, but added that there could be a payment of income to the spouse of one of the settlor's children, the settlor's children, and then that spouse. So whoever that child was, the one of, I think it was 4 or 5, as long as that child provided for the benefit in that person's will. So here we are, all of a sudden we've added a beneficiary. So the corporate trustee, not feeling very comfortable with that sort of direction, said, I think I need to go to court just to make sure that this is okay. So the court studied this and looked back to the very things we've been talking about and said, well, basically, the husband's power is a power of appointment, and if he could exercise that to go outright to these beneficiaries and use his absolute and sole discretion to make a distribution to a beneficiary, then that's in essence a fee simple type right to make a distribution in fee simple. Therefore, he should be able to make that and create a lesser estate in trust for the same persons. And oh, by the way, the fact that the child could add in their spouse, as long as that child named that person in their will, then it was okay. And so the court approved that and allowed them to create that new trust. So it's been around. There's a couple of other cases that are cited in your materials and all, but this is not new. Again, it's been here a while. So why would we ever even use this? Because if you study the code and you do reformations, you understand we can do court modifications. Well, that can be time-consuming, costly. Sometimes it's just not in the best interest of the beneficiaries to spend all the money. I, quite frankly, feel comfortable with modifications. I'm getting more comfortable with decanting, but it's still this new concept. But we might use it if there's been, the provisions of the trust are so antiquated that they're really difficult to administer. Or maybe there's an administrative provision that just really doesn't work anymore. I hearken back to the days, and I'm sure you all have seen trust, where the trustee is mandated to invest in bonds of a certain rating and that sort of thing. And quite frankly, with our new UPIAs and all that, that's pretty much gone away. We tend to broaden that and allow for a more broad investment policy. But, you see provisions that you go, wow, that's pretty restrictive. Well, when the trust was created 40, 50 years ago, it made perfect sense. So you might not want to allow for that broad discretion, or maybe the trustees, you've run out of trustees, and you want to be able to have some sort of succession plan or something of that nature. So it's really not changing the dispositive provisions. It might be purely administrative. Maybe there's been changes in, the law or the family situation that makes sense for you to be able to decant to a new trust. Not everyone is comfortable with that, quite frankly, I'll tell you. But I'll tell you there are a lot of people who are very comfortable with creating new trusts and decanting to it. I think other states that have had this sort of statute in effect for quite a while, they are doing more. I think you do have to be careful that every state statute, if you're going to work on a decanting, I know a lot of us do Delaware type stuff, or we may use other jurisdictions that we work with. You really have to learn and understand the implications of those statutes, because there's a lot of risk. I'll talk about that. In my opinion, there's a lot of tax risk that hasn't been addressed at this point under the IRS rules, so the code and the regulations, and so we're hoping to get guidance on that. But you really do have to be careful in the exercise of that. So this decanting in our world, it really relates to not a beneficiary's power of appointment, but it's really a fiduciary exercising a power. So you give the fiduciary the power to shift assets to a new trust. But the fiduciary is still just that. They are a fiduciary. So you can have, under even the restatements, a power of appointment is one thing, and that's generally your beneficiary or some party who has the power to direct or distribute these assets to this person. There's also the concept of a fiduciary distributive power. But when you pull those two things together, because the restatement third anticipates that a fiduciary could have a same type of power, this absolute discretion, but they still have to do that within the fiduciary standards. So we hearken back to what are the duties of that person? Well, the main ones are the duty of loyalty and the duty of prudence. So the duty of loyalty requires that that trustee, the fiduciary, exercise the power in the best interest of the beneficiaries. So is it, that discretion to distribute among those beneficiaries? And is that in the best interest of them? Well, I think that makes some fiduciaries pretty uncomfortable to have to say, wow, I really have a lot to think about. If I'm going to make a distribution, even though I have absolute discretion, I still have to do that within the purview of my duty, okay? So that does not go away. They have to be fair and impartial and not do things in their own interest. So they can't self-deal or do something like that. So if you have a beneficiary who's also serving as trustee, this becomes a real issue. And I think that's pretty self-explanatory, not to mention the tax implications to that person. So the duty of prudence requires the trustee also to make that distribution and decanting decision with competence. So I'm operating the trust property to be reasonable and with prudence. And in doing that, the decanting and exercising the decanting power, that duty still is there as well. So is that a good decision? Am I doing that in good faith within the terms of the trust? And then thinking in terms of what does Texas law require of me? Well, that is your duty, okay? You have to exercise that in good faith. The other duty that we have in Texas and is really part of the common law and in most jurisdictions is that to keep your beneficiaries informed. So when any trustee exercises a duty or has the operation of a trust and is administering that, they really have an obligation to keep the beneficiaries reasonably informed. Well, I know probably a lot of you, like me, have had people come in and say, I don't want the kids to know about this. I just want to put the money in there. They're still pretty young. We're just going to leave it there. And the first, words out of my mouth are, that doesn't work. You cannot sit there and completely say, I'm never going to tell anybody about this. You really, that trustee, whoever that is, and I'm certainly not going to be in that position of saying, I can't go and talk to, tell my beneficiaries about what's going on. And within that duty is the duty to account, to make sure that the assets are being managed properly, all of those things, and then keep those beneficiaries informed. So what happens if all of a sudden the trustee says, I'm going to exercise this power to decant, and the beneficiary says, I don't think I liked it? Well, as my friend Mickey Davis always says, that person is no longer really a beneficiary. They are a plaintiff. So they will obviously sue the trustee for breach of fiduciary duty and maybe have them removed and seek some sort of damages from them. So if you're not comfortable with decanting, you would naturally probably fall back to a modification. And modifications have also been around for a long time. We have the doctrine of deviation, which is an old rule that we could look to, judges could look to say, if the terms of the trust are such that really it's almost impossible or difficult to manage, then, the court can actually modify the terms of the trust in order to get around that. But they really have to consider a lot of things, the settler's intent, what's going on in that situation. So that's still there. Now, in Texas, we weren't always, very comfortable with that. The judges were very reluctant to deviate from the terms of a trust. So in 1984, we adopted a statute that basically brought in the doctrine of deviation, and we started seeing a little bit more of that. And then in 2005, we got our new provision of the trust code, which allows for judicial modifications and terminations. And under that, so if you're not familiar with and comfortable with that decanting, you can still default back to the modification. But that may not cover what you exactly want, because there's a laundry list of things that the judge would take into consideration. And when you actually file your application, then you're going to have to say, where do I fall within this, and why would the judge ever want to change that? I'm not going to bore you with each and every one of those. They're certainly there in your material and also in the statute for your reading. But you can still go back to that. You could also consider as an alternative a merger or division. Those you don't necessarily have to go, you don't go to court to get those. You can do those within the framework of the statute. But the beneficiaries have to be given notice under the statute, so they're going to know about it again. Certainly, if you do a court modification, you're required to give notice to the appropriate beneficiaries. And figuring out who all those beneficiaries are can be very difficult, very expensive, getting them served, getting waivers. Do you have some sort of situation where you've got multiple levels of descendants? Do you have a virtual representation issue? Some sort of conflict there where you can't really get around it, so judicial modification may not be your best option. So certainly can be a stumbling block, but again, if you want that comfort, that's going to be the direction to go. So the other thing that you could consider is a reformation or a rescission, and those are pretty limited to basically mistakes of fact, or not based on that, but where there's been a problem with that original trust, or maybe there is a trust that shouldn't have been created, so it should be rescinded. Not to bore you with the specifics of that, but those are really your alternatives. The last one that's there, and this is a common law alternative, which would be if you get agreement of all the parties. But again, it's sort of like what's there with the modification. Who all are you going to get to be included in that agreement? Do you know you've got everybody? If you've got a descendants sort of distribution, that can be pretty difficult. So getting everyone on board to agree to that can be the problem. Okay, so just a couple of minutes, I want to touch on a couple of tax issues. When you do your decanting, it's not just something that you just go and do and everybody's happy and we go off on down the road, because as you know, anytime you're moving or shifting assets, there can be potential tax consequences. Now, most of the time, your decanting is not going to cause income tax consequences. But if there is some shifting of some interest that might be treated as an exchange or something, then you may have some income tax consequence to that. So just like you do in any other analysis, when you're moving assets around from one party to another, it's no different. You should treat this exactly the same for your analysis purposes. Now, I will say that our Texas statute has a savings provision that basically for most of your tax benefits, if there's been some tax benefits such as a marital deduction or a charitable deduction or something like that, there's a savings provision that basically says you can't decant if you're going to lose the benefit, that tax benefit. So hopefully that doesn't catch anyone, but certainly worth consideration. Now, I know income tax is not what you came here to talk about, but again, just be very careful about any transfer that you're going to make. Gift taxes. So we all know that if there's some sort of transfer for less than full and adequate consideration, that there's the potential of a gift tax. Same thing here in your analysis. Second step after you've looked at the income tax possibilities are, what might be a gift tax consequence here? Is there some shifting of beneficial interest that could result in a gift tax to, one of the parties to this, maybe inadvertently? And so obviously they don't want to be caught unaware. One of the big ones that comes up is where there might be a change in your perpetuities period. This is, if you all have another one of those coin terms, the Delaware tax trap. So that if you are somehow going to a trust and you're going to give someone a right to extend that perpetuities period, that's going to be a problem. A lot of people now have savings provisions in their trust documents to avoid that sort of thing because we don't want it to happen. Right now, we don't have in Texas a savings clause for people who just inadvertently mess up. So you need to be very aware of that sort of thing, because I know a lot of planners and attorneys and the planners who aren't necessarily drafting this but who are working with the concepts are coming and saying, hey, I need this trust, and by the way, we're going to decant to a trust up in Delaware, and oh, by the way, they don't have a rule against perpetuities. And they may not know that. You better know it, because it's going to be a problem depending on how your trust is drafted. Okay, estate taxes. Generally, just because this is a shift from one trust to the other, you're not going to have an estate tax problem unless you have a Delaware tax trap issue. But you can't have a consent being required, so of your beneficiaries and all. And when we get to the Texas statute, I'll point out to you a provision that you may go, I don't understand why on this notice the beneficiary, it's kind of weird, it's a little bit nebulous, and why would we even say that? But if we required a beneficiary to do something or give up a right, that's in essence them releasing a power. So you might have an inadvertent tax consequence if that happens. So we've dealt with that under the statute. Generation skipping transfer taxes. The concept of decanting has really been covered on grandfathered trusts. There are two basic safe harbors for grandfathered trusts where you can actually change interest without jeopardizing your grandfathered status. Those are specified in there. It gives you, when each of those applies. But that's also been thought to cover decantings or even trusts that are not covered on. Maybe it's a trust where you've actually applied GST exemption to the trust, so not necessarily a grandfather trust. And the service has been very liberal in applying those rules that are related to the grandfather trust. So you're probably going to get the same application on a trust where you've actually applied exemption and created that trust with a zero inclusion ratio. Okay, charitable beneficiaries. If you've ever worked on a trust and done a modification or anything that had a charitable beneficiary, you know that the AG, number one, has the right to intervene on trusts in which a charity is a beneficiary. They also are required to be given notice if you're going to do anything related to that trust. I will tell you, just from the drafting standpoint, we worked very closely with the Attorney General's office in Texas on our statute to make sure that they were comfortable, and they actually were very good working with us, made some great recommendations, some things that we negotiated on, and they are to be given notice. But you'll see specific provisions related to what happens in a decanting where you have a charitable trust, and we'll go to that in a few minutes. Let's turn over and talk then about our statute in general, because there are things I want to point out to you that the basics of this are not that difficult, but I think in application, if I will agree with you that this right now is probably more limited. It is more limited than we had first envisioned. And a lot of that is because, I'll just be real frank, is that we in Texas tend to be very conservative when it comes to changing trusts that we consider irrevocable. We also are very conservative in our application of various laws, and with the great people who do a lot of work on all our behalves on the legislation, doing something that would somehow open the door to a lot of abuse, that's just not something that we want to do. We don't want to go far back and then rubber band back. So the idea was, in order for us to even have a stab at getting a decanting statute, we needed to do something. And a lot of us felt that if we didn't do something proactively, we were going to have to do something reactively. Because what happens down in Austin oftentimes is that legislation gets proposed, and then you have the same people on the council and the bar having to react to, in a very, very tightened time frame, to legislation that's being proposed. And we didn't want that to happen with a decanting statute. We didn't want to be sitting there having to analyze a very, very difficult statute to understand, maybe drafted by someone who doesn't understand all of these rules, and then having to try to, in a very rapid-fire sort of situation, either modify what they were doing or try to use our chips to somehow get an agreement with whoever had proposed that. And this is not a criticism, but while they're down there and they're proposing legislation, senators and all who are actually filing legislation proposals, they tend to, because their constituents also often bring that to them, they feel very strongly about what they're presenting. So it becomes very political. This should not be a political process. This is something that, as the bar, we wanted to be able to have our hands in and have control of. So having something, maybe conservative, was a lot better than having nothing. So with that said, I'm going to jump into a couple of definitions. A lot of them are very easy to understand. But there's this concept of current beneficiaries, and then presumptive remainder beneficiaries, and successor beneficiaries. And this is not something that's been in our statutes as definitions. So a current beneficiary, I think, is pretty easy. That one basically is just a person who's eligible to receive a distribution of her income or principal on some given date. Then you have this presumptive remainder beneficiary. And that is, with respect to that same particular date, a beneficiary who, in the absence of notice to the trustee of an exercise of a power of appointment. So if I had a power of appointment and the trustee was going to decant, if I haven't told the trustee, or the trustee didn't know of my exercise of the power of appointment, the trustee can presume that I haven't exercised that power for purposes of doing this decanting on that when that comes up. And then assuming that any other powers of appointment are not exercised. So those persons that would be eligible to receive a distribution on that date, absent that notice and the exercise of some power of appointment. Okay, so on that date, you would look to see if the trust terminated, who's going to be a beneficiary, and if the interest of all those beneficiaries currently eligible to receive income or principal ended on that date without causing the trust to terminate. So take the snapshot, figure out if there's any powers of appointment, who might be eligible to receive a distribution if the trust terminated. Okay? So that's pretty easy. Then the successor beneficiary is any other beneficiary. Okay? So once you get those sort of three categories, it becomes a little bit easier to deal with. The other definition that I really want to be clear on is this concept of full discretion, because a lot of us feel that full discretion is, the trustee has the beneficiary to distribute in the best interests. Not here. It has to be something like the trustee has the discretion to distribute to anyone in this room, kind of thing. It cannot be limited in any way. Okay? I don't know that that's going to be changed anytime soon, but it is purely a full discretion, period, end of sentence. Anything that qualifies that in any way is not full discretion. All right? So that makes it a little easier to break into the separate pieces of the statute. So then we shift over to the two different types or two situations of decanting. So a trustee with full discretion, I can distribute to anyone in this room, basically. That person may distribute all or part of the principal of that trust to another trust, and in doing so, they can exercise it in favor of, to a trust that's basically to benefit maybe two people, part of the people, maybe in our situation, everyone on my right side of the room, and to the exclusion of everyone on the left side of the room. Because if I have the ability to distribute and decide you don't get a distribution, why shouldn't I be able to pick? So it is pretty easy to think of in terms of this broad discretion power. I can also, in that situation, if there's a power of appointment, I can grant, further powers of appointment. There may not be a power of appointment. I can create them. Because if I can distribute to you outright, why shouldn't I be able to do it to a lesser degree and give you a power of appointment in there? So that's the concept there. I will tell you that if you look at the last subsection of that particular section, you'll see this point that's made about the trustee has to exercise a decanting power in good faith in accordance with the terms and provisions or purposes of the trust and in the interests of the beneficiaries. It's really the requirement of a trustee anyway, even under common laws, to exercise in good faith, right? That's still their fiduciary duty. But I will tell you there was strong argument by some of our litigation friends, and when we were working on these provisions, saying, I don't like this. I mean, the trustee, we have these requirements and other provisions of the code that, the trustee has to exercise certain powers in good faith and for the purposes of the trust and in the interests of the beneficiaries. So while I think that duty has always been there, and but this was the addition that this wasn't going to happen, I promise you, without the inclusion of this particular provision in there. And it's also in the second decanting power, which is just a good segue to say the trustee, if it's not a full discretion situation, can exercise the power to decant when there's limited discretion, but only if they do so with certain limitations. So if you've got beneficiaries of trust number 1 and you're going to decant to beneficiaries of trust number 2, they have to be the same if you've got limited discretion. So even if that trust says best interest, something of that nature, you're going to have the same beneficiaries. If the first trust has certain language in there about how the distributions are to be made, anything of that nature, the same language has to be in the second trust. If there's a class of persons named as beneficiaries in the first trust, the class has to be the same in the second. You're starting to see it. Powers of appointment would have to be the same in the second trust. So in essence, if you've got anything less than that full discretion, that second trust from a distribution standpoint is going to have to be the same. You're not going to be able to get around that under our current statute. So if you can't get around that, you're going to have to default back to one of the other options that I touched on, modification, agreement of the parties, something of that nature. You'll see again that good faith requirement that I talked about previously. Okay, so with that being the case, and I know you think this is a really long statute, Shannon, and it's great, but isn't that pretty limited? And I'll tell you, yeah, it's pretty limited. for the most part, in most of our trusts that we're going to want to decant are those that probably have some sort of limitation on discretion, including best interest. We don't see that much anymore, but if you've got an ascertainable standard, you're in that second set, and your ability to use the decanting statute is going to be limited to things more like administrative problems. Just, that's it. That's where we are. But it's something, okay? All right, so what happens if you said, okay, I can get around this, I think we can decant. What do I got to do to get it done? Well, you're going to have to give notice. And the notice provision is pretty clear to say you can do it without consent of the settlor or the beneficiaries of the trust. So that gets around a lot of stuff that you have to go with modifications and things of that nature. And without court approval, if you provide notice to the current beneficiaries and the presumptive remainder beneficiaries. Remember, we talked about current beneficiaries, presumptive remainder. Take the snapshot, figure out who they are. That's who you give notice to. So you have to tell them, I'm going to exercise this power to decant. And you have to add a lot of stuff in there. You have to basically tell them that, hey, I'm going to exercise this power. And, oh, by the way, you have the right to object. Okay? Well, they should probably know that, you would think, but you have to tell them about it. If the charity is a beneficiary of the trust, you're going to have to give the AG that notice. You're also going to have to give the AG notice if there's an unclear, let's say you have a charity and they're no longer in existence. You're still going to have to give the AG notice. You're also going to have to give the AG notice if charities aren't really named by name, but maybe there is a clause that says, hey, the trustee has the right to distribute to charities unnamed as long as they qualify as 170B1A charities or something like that. Still going to have to give the AG notice. So, again, always bring them in that circumstance. Trustee does not have to give notice to a beneficiary if that person's known but can't be located after reasonable diligence. You better keep good records and make sure you figure out if that trustee, exercised reasonable diligence. If the person's not known to the trustee, or if the person waives the requirement of notice, which is what you hopefully get, or is a descendant basically in a situation where someone who has a like interest above them, it's sort of a virtual representation kind of situation where there's no conflict if that person has been given notice. So they have to include a statement that says, I'm going to exercise the power, you have the power to object, and then the beneficiary can turn around and decide, well, what am I going to do? Now, if the beneficiary objects, then the trustee has the ability to say, well, I can still go to court. The beneficiary's objection does not necessarily stop everything, because there's where we want to be concerned about any kind of gift tax or estate tax consequence, because you have a beneficiary has the ability, if they don't do something, that's somehow the release of a power, okay? So, or a lapse of a power that could cause gift tax consequences. So we didn't want to have that situation, and that's why that particular provision is written the way it is. It was a long discussion about how do we get around that? How do we get around inadvertently creating some power? And this is where, I will say, if you're not familiar with those sorts of rules, if you go and you're working on a decanting in another state, I've seen statutes that have those types of provisions, and you need to be very careful about understanding or getting local counsel and tax counsel to work through that with you. You have to specify the purposes. Why are you doing this? You better have a real good reason for going and saying, I'm going to decant, and I just decided I'm not going to tell you why. That's not going to work very well. You have to give the name and address of the trustee. Obviously, it ought to be fair to your beneficiaries to know how to get in touch with the trustee and how to, if they're going to file some objection or a court proceeding, the beneficiary has the right to come and petition the court to say, yeah, court, I want you to go ahead and do this, authorize this decanting. So they should have the address of the trustee and able to be able to include them. They have to include a copy of the existing trust as well as the new proposed trust. So you can't mess around and be saying, I'm going to be drafting this trust while we're working on the court proceeding. You need something in hand ready to go, and it needs to be you need to have considered all those provisions when you go and give that notice to that beneficiary. And then you have to do it within 30 days of the decanting. So 30 days before, you better make sure your notices are given. You have to send it by registered or certified mail with a return receipt or delivered in person unless they waive it. And you're going to want to make sure that you get your green receipts. If you don't get a green receipt, you need to do something else and get it to them either by a delivery service, someone who can serve that on them, almost like a service of a citation. There has to be a written instrument. I think that makes pretty good sense for all of us, but you can't just make it up. And so you're going to have to send it to them anyway, so that's sort of a given in that situation. I'm going to skip over a couple of things. I think some of those make sense. The court-ordered distribution section allows an authorized trustee to petition the court to order a distribution under this chapter. This would give your trustee at least some comfort in saying, I went to the court, I asked for the court's blessing. I've not heard of any proceedings thus far. I would love to be a fly on the wall for the first ones of these that come through to see how that goes. But the beneficiary can also ask for the court to approve or disapprove and say, no, judge, this, really, this shouldn't happen. So if the AG objects to the decanting, the trustee has to go. And if they're going to move forward, they have to go and get a court to approve that decanting. So they're the ones who kind of, in their own right, have a veto power over that. And they are not afraid to exercise that, trust me. The statute talks about in terms of the trustee having the ability to go to court and they may present evidence. If I'm the judge, and I know our statutory probate judges, if you show up, you better have some good reasons for wanting to decant and not do a modification if you're going to seek their approval of a decanting. If there's divided discretion and you have a trustee who basically has certain distribution powers versus another, so if you have a trustee that has full discretion and one who has limited discretion, the trustee with full discretion could exercise the broader power to distribute and decant, or the one with lesser discretion can exercise the power to under the second option. Later discovered assets. Let's say you've decanted all of the assets of one trust to another trust, if an asset is later found, what the consequence under the statute is the later discovered asset is treated as part of the first trust and should be owned by the second trust. But if there was only a decanting of part of the trust, then that asset that's later discovered stays in the first trust and you'd have to do a new decanting. So I think that makes good sense. The trustee isn't obligated and does not have a duty to inform beneficiaries of this right of decanting under state law. I think that's good because in this day and age, you know as well as I do that beneficiaries who decide they're mad are going to look for every reason to sue a trustee when they're already mad. So keeping beneficiaries happy is important, but making sure that trustees are protected as well when they're doing good things in administering trusts. Just the ability to do this should not put them somehow in jeopardy of being sued. Okay, there's some prohibitions on distributions that I talked about. The trustee, in essence, cannot exercise a power to reduce, limit, or modify a beneficiary's current right or vested right to receive a mandatory distribution of income. So let's say under a marital deduction trust, obviously the spouse gets the right of income to be distributed at least annually. You can't change that. They can't do it to change any requirement to receive a mandatory annuity or uni trust interest, same sort of type required distribution, or withdraw a percentage of the value of the trust. So if I have a right to my 5 and 5, I still have that right. They can't change that. Or to specify or to limit my ability to get a specified dollar amount. So if it's $5, whatever, then I still have that right. And this one is the one that got thrown in there that most people are struggling with right now because this was a very heated, long discussion, I would say, with the various people involved in the analysis and consideration of the statute. But this is this prohibition that says you can't materially impair the rights of any beneficiary. That's pretty limited. And so that's why most of the trustees and everyone chewing on this right now are saying this is a pretty limited statute, and I will agree with you. That's the case. That's what we have right now. I will tell you there is some discussion that that's going to be at least tried to be changed. I don't know that it will happen, but it's still there for discussion. And I know some of you would probably be on the let's get it changed sort of side of the fence, but it's there, and there was a reason it was there. Okay, not to go into everything else, but the trustee, one of the big ones is the trustee can't decant solely to modify or change their obligations under a trust or to change their compensation. So they can't do it because that, in essence, is sort of a self-dealing, self-interest type distribution, and they can't do it. If they're going to do that, they better tie it to something else. Okay, so not likely to happen, but hopefully. And you also can't exercise the decanting right to limit, reduce, or modify a perpetuities provision in the first trust unless it's permitted by that first trust. So this will help, with some of the problem trusts that you might have an inadvertent Delaware tax trap issue or some sort of problem with that. And then there are the tax-related limitations that are basically your savings clause to say, oh, and by the way, we don't want anyone to inadvertently screw up trusts that already have a lot of tax benefits or are protected and inadvertently cause a lot of tax consequences, which are going to mean the beneficiaries are not very happy. So hopefully that will protect a lot of people who might inadvertently do something. I am at 1 minute, so thank you all. Hopefully that gives you some insight into our new statute. It's there. Chew on it. Feel free to, email people who are involved in this to give your recommendations. If you think that you have some sort of change to the statute, thoughts on it, want to be involved, things like that, because there's a lot of stuff going on. And while this is a start, it's merely a start. So thank you all. Have a great day.
All right. Thank you, Ms. Guthrie. Okay, it is now time for our first break. There are snacks and refreshments back in the forum where you guys got breakfast. So that clock is a little fast, so we'll be back here at 10:20. The next presentation will begin.